News, Nairobi.
Thank you, Vera, for that. Now, the Lands Court was established following proposals contained in the Kenya's 2009 National Land Policy. The proposal was subsequently anchored in the 2010 Constitution and operationalized through Environment and Land Court Act of 2011. Now, in a released use operation manual on the establishment divisions, the presiding judge of the court observed that during the 10-year court anniversary celebrations, stakeholders indicated that an increasing number of cases brought before the court pertaining to land rather than environmental concerns. In response to that, the court reached out to Lady Justice Martha Koome with the idea of restructuring. Subsequently, Land Division and the Environment and Planning Division of the court were created and became operational in July 2023. Now, this morning, I'm joined by Judge Jacqueline Mogeni, who is a judge at the Environmental and Land Court. Thank you so much for sparing time for us.
You're welcome. Thank you for having me here.
Karibu sana. Let us just get right into it. And last year, major changes came up in the structure of the environment. And there are two divisions, the land matters and environment and planning matters, right?
Yes.
What was the need of having these divisions?
Okay, as you said in your intro, when we held the court observed the 10 years. First, before I start, I really wanted to also, like every other Kenyan, send my condolences to the family of the General, CDF for Kenya, Ogola, and also the families of the other 9 military officers that lost their lives in the crash. It's a sad day for Kenya. And may God give peace and comfort to their families. So as you said in your intro, the reason why this court actually was established, it's because of the 2010 Constitution, where Kenyans said we want a land court. We want our matters to be resolved by a specialized court because the land matters were really queuing. They were taking so long. And so at when we were marking the 10-year celebration, we were calling it ELC at 10, we had a conference in Kilifi. What came out of the discussions with the Kenyans again was that they wanted a division, a separate division that would deal with the matters of environment, still under the land court, but these matters should not queue so that they don't take long in court, because environmental matters are actually time specific. You know, if somebody is clogging a river, if you don't deal with it immediately, people won't have water downstream. So it was as a result of that Kenyans asked for it, and our PJ, our principal judge, Judge Angote, asked the CJ, and the CJ graciously allowed the court to form 2 divisions administratively so that we could be able to handle the land matters separately in a different division and the environment matters in a different division, purely for administrative purposes and to ensure that the environment matters don't queue because of the urgency of the environmental issues. Yes.
So basically that is what, because you are under the Environment and Land Court.
Yes.
What are the specifics that you deal with?
The normal issues, because what the law says, the Constitution says, this court was set up to deal with environment issues and matters relating to title, ownership of land, occupation and possession and transfer of titles. I mean, everything that's got to do with the ownership and everything that has got to do with the climate change, climate issues, environment issues. So issues of pollution of rivers, noise pollution, air quality, land issues, transfer of land from one person to the other, sale of land, occupying of the land, all those issues, anything that has got to do with use and occupation of land.
All right.
Yes.
And well, you've just said rightly that some of the cases that end up in your side is more of like pollution and so on and so forth.
Yes.
We've had so many cases of some maybe industrial plants that are polluting the environment, and the cases have dragged on for years. So what makes such?
I think there are many issues that contribute to that.
Yes.
You see, the matters come to court. As we are sitting in court, we don't go out to look for matters as judges. So the parties bring their disputes to court. And the judges or the judicial officers are ready to listen to you today and finish your matter.
Yes.
But you see people come to court and say, I'm not ready, I have not been able to file a response. Or maybe you came under a certificate of urgency and I gave an order and said, go and serve, in 3 days come back. When you come to court, you say, I didn't serve. Or the person who was served says, I was served, but I've not gotten instructions from my client. So that's why matters drag. But for environment matters, the court has since moved to say that these are very urgent matters, and when you're served, please respect the time frame that has been given, because time doesn't wait. You see, if there's a pollution on, for example, air pollution, or even the basic noise pollution, people can't sleep. We can't wait for people to not sleep for 1 year. I mean, there'll be zombies. So some of those matters are very, very urgent. So we try to ensure that we do not allow for unnecessary adjournments that would defeat the purpose of justice. Yes.
Because sometimes we hear cases drag on and on because these parties, there are some parties whose aim is mainly just to drag on the cases.
Which is
that is
true
what you're
also.
saying you're trying to.
Yes, to limit that. The Chief Justice has actually guided, and also the courts are in agreement that we should try and really minimize adjournments for any matter, be it a land matter or an environment matter, to maybe a minimum of 3. And also they shouldn't be so far apart, so that we can be able to finalize these matters, because there's a maxim in law that says justice delayed is justice denied. So the longer I take, the longer the suffering. And so we have to ameliorate the suffering of Kenyans and ensure that we resolve our cases in a just, efficient, and a timely manner, so that people can see this is justice. They have, like, when this court was formed, when this court was inaugurated, there are matters that we were dealing with that were have been lying in court since the early 70s. Some matters are as far back as 1970 something. So you can imagine, then 1980 something, then 1990 something. So we are in 2000s. So we are trying to really clear that, because some of the people have actually died. And so we are telling ourselves, people shouldn't die waiting for justice. It's not fair. It's not fair at all.
As a judge, I can imagine your frustration when you think that, we're getting done on with this matter today, then maybe the advocates come with different forms of excuses just to continue dragging on that matter. And since now it's almost a year since the division, is there any case that has been prolonged since last year? And maybe what do you think about it?
You see, the division was created when we already have aged matters, let me call them as such.
Yeah.
Environmental matters are not so many. Because of the division, now we are seeing an increase in the filing of those matters, environmental matters. And we try to resolve them at most within a year. They should be done. But land matters will drag on for obvious reasons. We already, some of them, as I said, we found them there. But one of the things we are doing now, we do what we call RRIs, the Rapid Response Initiatives, service weeks, to ensure that we clear most of the backlogs. And we prioritize any matter that is more than 10 years or 5 years and above. Every first week of the month, we actually list those matters for hearing. And we are a bit stringent on adjournments for all litigants. We implore them and ask that we truly move on. And so sometimes, of course, the lawyers are not happy and the litigants when they want adjournments, but it's all for justice. So let's clear the matter. If you're not happy, go to the Court of Appeal. If you're not happy, find another way. Or some of the matters, there are matters that have stayed in court for long. And when you go through it, you realize this is something that can be negotiated out of court. We have encouraged ADR, the alternative justice. We ask, can you go and speak? Can you go and try and negotiate? And we give you 30 days. If you've not been able to resolve it, come back, and I can prioritize and hear you within a week. We are done. And within 60 days, you have your judgment, or less days, because some matters are really not so complex that will require 60 days. Some of the judgments within a month, within 2 weeks, we are done and we deliver them.
Yes. And perhaps speaking about the ADR, that is the alternative dispute resolution, how can the Environment and Land Court implement it fully? Or how are you going about it to ensure that it's implemented?
Anytime a matter comes before us, we encourage the judges. The first question we ask is, have you tried to negotiate this out of court? And we encourage that a lot. You saw the matter that came before my court. I can speak about it because we already referred it to ADR on the issue of the lion that died in Narok. We referred that to ADR because it's an issue that involves Kenyans, the interest of many Kenyans, the conservationists, and we said, why don't we try and talk over this and see how best we can be able to resolve this? Because some of the solutions actually lie in the communities. They are not in the courts. They lie in the communities. The other reason why we try to encourage ADR, because you see when the matter comes before a judge, it is a win or lose.
Yes.
But when you resolve the matter and settle it and talk over it, even if you are disagreeing with your neighbor, it is a win-win. Because you'll say, okay, I know I did wrong. Why don't we settle it 60-70, 60-40, I mean 70-30. So when you resolve matters out of court, it's a win-win. When you allow me to decide over that matter, it is a win-lose. It is very rare that it will be a 70-30 situation. So that is why we are encouraging. The first question we ask is, would you like to talk to each other first? If they say no, some parties come and they're like, no, I just want the court to decide my matter. Then we have not, because that is the reason we are there, to resolve disputes. Yes.
Now, and when also when we talk about the environmental and land courts, environment in itself, what is the court doing? Because at the moment there is so much in terms of environment, right? Yes. What is the court in itself doing to avert, environment disasters, not only in the country, but also not only in Nairobi, but also in other parts of Nairobi? Talking about climate change, what is the court doing?
Yeah. When we were in the university studying law, we were never taught about climate change. Of course it was there, but it was not a topic.
Yes.
And so one of the things that our principal judge has done, he works very hard to ensure that we get trainings and exposure. Okay. So a lot of all the judges in the Environment and Land Court we are undergoing periodical trainings to familiarize ourselves with the issue of climate change, carbon credits, just transitions, all those emerging issues, so that we are all aware of what we need to do. Because these issues are going to come to us. We are the ones who are going to make the judicial decisions about them when people disagree out there. And so the first thing is training. The other thing is sensitization. We are doing a lot of CSR, community things in the communities. All the courts, like now on the 24th this month, on Thursday next week, all the environment and land courts in the Republic of Kenya will be growing trees in all the counties where we are. We are in 40 counties. And so in all the 40 counties, all the judges will be out. We are not going to have a course list on that day. We've already told the litigants that we will be out to do a CSR, and also an open day to sensitize the communities on who is the court, what is the court here for, what do we do, and how do we engage with each other. And we'll adopt, like Nairobi, the Milimani Court will be adopting a certain section of the Nairobi River, clean up, grow trees in Korogosho, and actually just have that area adopted. We'll adopt it and take care of it for the rest of our lives. I mean, for the rest of the lives of the court. Yeah, so it's really not hinged on we as the judges, but it's about the court. And so the court continues to collaborate with communities to create sensitization. And also some of the sessions that the communities do on AJS, the courts attend to encourage them that this is the way to go. Because we know that the issues we have can be resolved in the community. Allow me just to add something about the land court, the land division that was created. The reason why the land division was created is because we realized, as I said, the solutions, truly speaking, are not only in court. The solutions are in the communities. So we divided Nairobi in 4 boroughs, and we have created what we are calling working groups for every division that involves all the actors, the stakeholders in that particular sector, including the National Government Commissioner's Office, the county governments, every actor is in that particular working group, so that we try and look at what is this that is plaguing Nairobi. What are these complex issues about land? Because the land issues in Nairobi are very complex, extremely complex. And so it's important that we have all stakeholders to say, actually, this is where the problem is, because Nairobians know where the problem is. Yes.
All right, let us talk about, as you said, land issues, mostly in Nairobi. It's a problem, and almost every day something concerning land is happening.
Yes.
If perhaps I could get your insights, because maybe somebody wants to get your insights on if my land that I have wants to be demolished by the government for reason A, B, C, D, and I have the title, but maybe you have like the government say, you don't own that land, but I have the title. Of course, the biggest problem nowadays is titling, because maybe you can get titles that are legit, others are not legit. How you don't even know whether you're getting a title that is legit or not. I know you deal with so many cases nowadays
Yes.
in regards to that. Perhaps what can you say about it as well?
You know, the process of ownership of land, any title, is very clearly spelled out in the Land Act.
Yes.
There's something we call in law the root of title, a title. It
yeah.
could be a genuine title, but the question is, how did you get it? What is the root of getting this title? And so anytime a judge is sitting over such a matter, the first question you ask yourself is, how did they end up with this title? There could even be 5 titles on the same piece and everybody's saying it's genuine.
Yes.
And so we have to examine the procedure that led to you owning this title. How did you get 5 genuine titles, really? It's ridiculous, actually. But that is the ridiculity that we deal with in court every day. And so as much as you will appear before me and you will be telling me to give the answers, it is the evidence that you will present. And I almost usually say land matters are black and white. And people say, no, they are complex. They are black and white. They're black and white in the sense that it's either that amongst these 5, there's one that is truly genuine.
Legit, yes.
And that one that is truly genuine, you examine the route that led to that ownership. And if there was any transfer, how was it transferred? Were the proper documents signed? Is it genuinely signed by the people who were supposed to sign and do the transfer? And was everything that was supposed to be done? Was stamp duty paid? Was everything that was supposed to be done? So Kenyans know those processes. And Kenyans know when they actually have fake titles, but they still come to court and present as though they have real titles. So, and you see such issues, you can't, if they could go out there and settle, I really don't know how you can settle with somebody a fake title. The genuine person who owns the land needs to be given the land. And a lot of times when you hear the court has made a decision, from the evidence that has been presented before us, that is the only decision I could make. And so, that is my finding, that this is the genuine title. And if I'm wrong, as I have said, we have the Court of Appeal. And if the Court of Appeal is wrong, you have the Supreme Court. So the beauty is, it doesn't end with me. So anytime you find that we've said this is the genuine title, sincerely speaking, we've examined every evidence before us, and that is what we've come up with.
Land title is very, should I say, complex in the country, because of this year, I think it's becoming
very, very complex.
Yes. But we are going to get back and delve deeper into that conversation. Now, please allow us to take a very short commercial break. But that conversation, we continue with it after this.